On January 3rd, the FTC held its first pretrial conference in its lawsuit against Microsoft to block the Activision Blizzard deal from going through. In this video, we'll listen to some sound bites from that hearing, that conference, and I'll share some of my initial thoughts about it with you. If you watched my other videos on this lawsuit, you know that last month the FTC sued to block Microsoft's $68.7 billion acquisition of game developer Activision Blizzard. The next day after Microsoft filed its response, the chief administrative law judge named Michael Chappell ordered a scheduling conference for the new year, January 3rd. Now, on January 3rd, the parties all got together with their lawyers and phoned in to this conference call with Judge Chappell. The FTC actually posted a toll-free number to its website that members of the public and journalists could actually call in if they wanted to listen in on the scheduling conference. And special shout out to YouTube channel Destin, who recorded the conference call and uploaded the entire hearing recording to YouTube. Thank you very much for doing that. Now, apparently there were a lot more callers listening in on that call than were expected.
I will say that we have had an unexpected turnout of people calling in to monitor. The operator has doubled the number of lines available, and anyone else who's tried to get in, we've done all we can at this time. I've chosen to conduct this scheduling conference telephonically rather than via Zoom video. This choice will save time and resources, as we can avoid engaging an entire video trial team for a short scheduling conference, which is merely procedural and is not evidentiary.
By way of background, a scheduling conference occurs at the start of a lawsuit, almost every lawsuit, and the parties don't argue the merits of the case at the scheduling conference. They don't present evidence. There is nothing argued really at the scheduling conference at all. Instead, it's an opportunity for the judge to meet the lawyers and for the judge and the attorneys to look at their calendars and agree on deadlines for completing discovery, filing motions, and other things like that that need to occur before trial, or in this case, the final evidentiary hearing in August of this year. Now, later in the call, while Judge Chappell was trying to get Microsoft's attorney on the call, he commented that the number of callers listening numbered in the hundreds, which is kind of crazy for a basic scheduling conference that does not touch the merit.
Thank you. And if someone out there can send her a text, that would also be helpful. Someone who's part of the hearing, not part of the hundreds who are listening.
After the attorneys for the parties had all stated their appearances on record, the judge asked the FTC to confirm that there were no parallel proceedings going on at that time.
I have a question for the government. As far as I know, there is no parallel proceeding pending before any U.S. district court. Is there any update on that?
This is James Weingarten with the government, Your Honor. You are correct, sir. There is no further update. No parallel proceeding.
And is there any plan for one?
Not at this time, Your Honor, only if it were to become necessary at some future date.
Parallel proceedings refers to two or more legal proceedings related to the same event or set of facts that are pending at the same time. So the FTC filed its complaint in its own administrative court instead of a district court of the United States. But to actually stop Microsoft from completing its deal to acquire Activision Blizzard, the FTC would have to file a parallel proceeding in a U.S. district court that would then issue an order stating that temporarily, until the administrative process in the FTC is done, Microsoft, you cannot complete this transaction. You must freeze the transaction until you are done going through the administrative hearing and the FTC has made its final decision. Then the judge turned his attention to the actual scheduling order.
The parties were provided a proposed scheduling order in advance of this conference. The parties have jointly proposed several changes to dates and to additional provisions in the scheduling order. These changes are acceptable and will be incorporated in a scheduling order, which I will issue shortly.
It sounds like the lawyers are at least cooperating with each other well enough to come up with some agreed dates in the scheduling order. So that is pretty typical, even between lawyers who absolutely can't stand each other. It's a matter of common professional courtesy. Then, moving on, the judge asked the lawyers whether there had been any settlement negotiations.
Let me ask about settlement discussions. I trust the parties have attempted to settle this matter. Does the government want to go first and provide the status of settlement discussions?
The FTC's lawyer told the administrative law judge Chappell that there have been no meaningful settlement negotiations to date.
Yes, Your Honor, this is again James Weingarten with the government. Leadership for the Bureau of Competition has directed respondents to engage with staff directly. We are always open to any remedy or settlement proposal, either in litigation or before litigation. There are no substantive conversations happening at this time.
When you say to engage with staff correctly, who do you mean by staff?
Me, Your Honor.
Okay.
When asked about the possibility of settlement and whether she had any additional comments, Microsoft's lawyer said that Microsoft is preparing for all options. She mentioned that the deal has to be closed before the termination date of July 18th, 2023. So that means the deal must close under that termination date before the evidentiary hearing that is set for August of 2023. So she also mentions that if Microsoft moves forward with closing the deal, that she fully expects the FTC to have to file a parallel proceeding with a district court getting that injunction to freeze that transaction, at which point they will consider what their options are. They will consider challenging it in the district court and whatever other options are available to them.
Yes, Your Honor. This is Beth Wilkinson on behalf of Xbox. Part of the reason we were able to engage with complaint counsel and come up with a more expedited schedule is, as you may know, the deal is undergoing review over in Europe and in the United Kingdom, and we're hoping that that will be resolved. And if there are remedies that are appropriate, that we can come back to Mr. Weingarten and the FTC staff to talk about a resolution. If not, as he was suggesting, and we have to go, the deal then could go forward and could close, we assume that the FTC would make the decision to go to federal court. And that's why we wanted to kind of front load the discovery in case they were to move it, because we have a termination date of July 18th, 2023. So we kind of are preparing for all options, either resolution if we can, which would be ideal, or a trial in front of you, which of course is fine and up to the FTC, or federal court.
Now, there are going to be many updates coming out of this lawsuit in the coming weeks and months, so make sure to hit the subscribe button below and turn the bell notification icon on so that you do not miss any of those updates. And then also leave a comment if you want to continue seeing content like this. It helps me to know what videos to make next and what you guys want to see. So in any case, that's all I have for you today. Thank you guys for watching.